You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Government access to private sector information has long been an area where privacy and security interests collide, and Domain 3 introduces the essential terms governing this balance. The Right to Financial Privacy Act serves as a starting point, restricting how government agencies may access individual banking records. Passed in the wake of concerns about unchecked surveillance, the RFPA requires that federal agencies obtain customer consent, a subpoena, or a warrant before accessing financial records from banks. This law creates a baseline expectation that personal financial data is not freely accessible to government investigators. For exam purposes, candidates should remember that RFPA does not prevent all access, but rather imposes procedures and notice requirements, giving individuals some level of transparency and recourse. It represents the first major attempt to regulate financial privacy in the face of growing investigatory powers. The Bank Secrecy Act, by contrast, demonstrates how privacy is sometimes curtailed in the interest of national security and financial integrity. Enacted to combat money laundering and other financial crimes, the BSA requires financial institutions to maintain records of transactions and report suspicious activity to regulators. While this improves law enforcement's ability to trace illicit financial flows, it also means that ordinary customer transactions may be subject to extensive scrutiny. The key terms here include currency transaction reports and suspicious activity reports. For exam candidates, the BSA illustrates how privacy and compliance obligations can work in opposite directions, requiring financial institutions to disclose customer information proactively, even while other laws, such as RFPA, impose restrictions on access. This duality makes financial privacy one of the more complex areas of U.S. law. The Electronic Communications Privacy Act broadened privacy protections to cover digital communications, but also created structured avenues for government access. The ECPA is divided into key parts, including the Wiretap Act for in-transit communications and the Stored Communications Act for data at rest. Each establishes procedures and thresholds, such as warrants or subpoenas, that law enforcement must follow to access information. For learners, it is important to note how ECPA distinguishes between real-time interception and stored content, reflecting different privacy expectations. This law illustrates the challenge of translating constitutional protections into modern technologies. Exam questions may test whether candidates recognize which authority applies in a given scenario, such as whether accessing emails stored on a server requires different legal instruments than intercepting a live phone call. The Communications Assistance for Law Enforcement Act, or CALEA, highlights how technology providers are drawn into surveillance compliance. This law requires telecommunications carriers to design networks that allow lawful interception capabilities when ordered by law enforcement. For candidates, the critical term is lawful intercept, emphasizing that access must be authorized through proper legal procedures. CALEA balances privacy with enforcement needs by ensuring that surveillance is technically feasible without granting unrestricted access. On the exam, questions may focus on which types of providers fall under CALEA obligations and the limits of those requirements. For privacy professionals, CALEA demonstrates how legal frameworks shape not just practices but also technical design, embedding surveillance readiness into communications infrastructure. National security surveillance introduces another set of terms, anchored by the Foreign Intelligence Surveillance Act. FISA created specialized courts to review government requests for surveillance related to foreign intelligence and national security. Unlike traditional criminal investigations, FISA proceedings are secret and focus on intelligence collection rather than prosecution. Section 702 expanded these powers to authorize targeted collection of foreign intelligence from non-U.S. persons located abroad, though incidental collection of U.S. persons. Data has raised controversy. For candidates, understanding FISA requires familiarity with both oversight mechanisms and criticisms of transparency. These terms highlight the ongoing tension between national security imperatives and individual privacy rights. On the exam, Expect scenario-based items where recognizing whether an activity falls under FISA or ordinary law enforcement frameworks is critical. National security letters represent a narrower but powerful tool, allowing agencies like the FBI to compel companies to provide certain records without court approval. These letters often come with gag orders preventing recipients from disclosing their existence. The scope typically includes subscriber information, billing records, or transactional metadata rather than full content. For learners, the key issue is the limited judicial oversight compared to warrants or subpoenas. Exam stems may test whether candidates understand the distinctions among government access mechanisms, with NSLs serving as examples of expedited but controversial tools. Recognizing their scope and limitations helps clarify how U.S. privacy law distinguishes between ordinary criminal processes and national security investigations. The USA Patriot Act expanded investigative authorities after September 11, 2001, reshaping the privacy landscape. Its provisions broadened the use of surveillance tools, increased information sharing among agencies, and lowered thresholds for certain investigations. Key terms include expanded definitions of terrorism-related activities and provisions for roving wiretaps. The Act illustrates how crises often prompt rebalancing between privacy and security, sometimes at the expense of individual protections. For exam candidates, it is important to understand both the specific powers granted and the controversies that followed, particularly regarding bulk collection of communications metadata. The Patriot Act serves as a reminder that privacy law evolves with national priorities, sometimes dramatically. In response to criticisms of overreach, the USA Freedom Act introduced reforms to the bulk collection programs initiated under the Patriot Act. It limited government access to large-scale telephone metadata and introduced transparency mechanisms, such as requiring more public reporting of surveillance activities. For learners, the Freedom Act illustrates the cyclical nature of privacy law, where expansion of surveillance powers is often followed by retrenchment and reform. On the exam, questions may test whether candidates can distinguish between the broad grants of authority under the Patriot Act and the later restrictions imposed by the Freedom Act. Together, these statutes represent the evolving balance between liberty and security in the post-9/11 era. The Cybersecurity Information Sharing Act of 2015 created a framework for sharing cyber threat indicators between the private sector and government, offering liability protections for companies that disclose data. The law's goal was to improve collective defense by encouraging transparency about threats without fear of lawsuits. For exam candidates, key terms include liability protections and cyber threat indicators. CISA reflects how privacy law increasingly intersects with cybersecurity, requiring organizations to weigh the benefits of sharing information against the obligation to protect personal data. This law underscores that privacy professionals must navigate not only traditional compliance but also emerging areas where collaboration is mandated or incentivized by law. A firm grasp of subpoenas, warrants, and court orders is essential for distinguishing levels of government authority. Subpoenas typically require the production of records but may not involve judicial approval. Warrants, by contrast, demand probable cause and are issued by a judge. Court orders fall in between, often requiring specific thresholds short of probable cause. For candidates, recognizing these distinctions is critical, as exam scenarios may test which instrument is appropriate for accessing certain types of data. These terms illustrate the layered protections in U.S. law, where access to information is calibrated to the sensitivity of the data and the strength of justification provided by investigators. Stored data and cloud service provider considerations complicate government access further. Questions of jurisdiction arise when data is stored across borders or within global cloud infrastructures. For example, a U.S. warrant may compel disclosure of data stored on servers in another country, raising conflicts with foreign privacy laws. Providers often challenge such requests, leading to evolving case law. For exam candidates, the key takeaway is that cloud storage introduces uncertainty and jurisdictional complexity not present in traditional record-keeping. This highlights the importance of understanding how technological shifts reshape legal doctrines. making stored data an increasingly contested area in privacy law. The Privacy Protection Act of 1980 created specific safeguards for journalists and newsrooms, restricting government searches and seizures of materials. The goal was to protect freedom of the press by limiting government intrusion into editorial processes. Key terms include work product and documentary materials, both of which receive heightened protection. On the exam, this law illustrates the principle that privacy is not only about individuals, but also about institutional functions critical to democracy. Understanding the PPA reinforces the broader theme that privacy frameworks often serve multiple societal goals, balancing enforcement with protection of core freedoms. Electronic discovery, or e-discovery, highlights how privacy plays a role in civil litigation. Parties in lawsuits may be compelled to produce large volumes of electronically stored information, which can contain sensitive personal data. Terms such as litigation hold and data minimization are critical here. For exam purposes, candidates must recognize that e-discovery obligations intersect with privacy responsibilities, requiring careful handling of personal data while still complying with court orders. This area underscores how privacy law extends beyond regulatory compliance into the mechanics of legal processes, where mishandling information can carry both legal and reputational consequences. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Workplace privacy begins with the concept of notice and the reasonable expectation of privacy. Employees are often informed through policies or handbooks about the extent of monitoring or data collection in the workplace. Courts frequently examine whether individuals had a reasonable expectation that their actions, communications, or data would remain private. For example, if a company issues laptops and clearly states that activity may be monitored, the expectation of privacy is significantly reduced. Conversely, if no notice is provided, employees may have stronger claims to privacy. For exam purposes, these terms demonstrate the balance between organizational interests, such as security or productivity, and individual rights. The principle highlights how clarity of communication through notice policies is a key factor in shaping what employees can reasonably expect in the workplace environment. The Civil Rights Act of 1964, particularly Title VII, lays a foundational principle for workplace fairness that intersects with privacy. It prohibits discrimination on the basis of race, color, religion, sex, or national origin. In data practices, this translates into obligations to ensure that hiring, promotion, and monitoring systems do not create discriminatory impacts. For instance, data collected during recruitment or performance evaluation cannot be used in ways that indirectly disadvantage protected groups. On the exam, candidates should recognize that while this statute is not a privacy law per se, it shapes the legal context within which workplace data is collected and used. It underscores the reality that privacy cannot be separated from equality and fairness in employment practices. The Americans with Disabilities Act adds specific confidentiality requirements related to medical information in the workplace. Employers may collect certain medical details, often during accommodations or wellness programs, but the ADA mandates strict separation of these records from general personnel files. Access must be limited, and disclosures are heavily restricted. For learners, the critical term is confidentiality, emphasizing that even necessary data collection must be handled with heightened care. Exam questions may test scenarios where medical information is requested and ask whether confidentiality obligations apply. This illustrates how workplace privacy obligations extend beyond general monitoring and into sensitive categories of personal data, reinforcing the layered nature of employee rights. The Genetic Information Non-Discrimination Act, or GINA, expands workplace privacy into the realm of genetic data. It prohibits employers from requesting, requiring, or using genetic information in employment decisions. Genetic data includes family medical history as well as results from genetic testing. The law reflects growing concerns about how emerging science could create new forms of discrimination if left unregulated. For candidates, the key terms are prohibition and scope. Genetic information is not only sensitive but also explicitly off-limits for employment purposes. GENA demonstrates how privacy law anticipates technological developments, establishing protections before widespread misuse can occur. On the exam, learners should expect questions that contrast GENA's protections with broader employment privacy principles. Regulatory oversight of workplace privacy comes through agencies like the Equal Employment Opportunity Commission and the Department of Labor. The EEOC enforces anti-discrimination statutes, ensuring that data practices do not undermine equality in hiring or employment. The Department of Labor, meanwhile, oversees wage, hour, and safety regulations, sometimes involving access to employee records. For exam candidates, it is important to distinguish the roles of these agencies and understand their impact on privacy obligations. Questions may test which agency has authority in particular contexts, highlighting the regulatory patchwork that defines workplace law. Recognizing these actors prepares learners to situate workplace privacy within the broader enforcement landscape, where multiple agencies shape the rules and expectations. The National Labor Relations Board introduces another angle on workplace monitoring. Under labor law, employees have rights to engage in concerted activity, such as discussing working conditions or unionizing. Monitoring that interferes with or chills these rights may be restricted. For example, excessive surveillance of employee communications could be challenged if it discourages organizing efforts. For candidates, the key term is concerted activity, linking privacy to collective labor rights. Exam questions may ask whether monitoring practices cross the line into unlawful interference. This highlights the theme that privacy law in the workplace is not only about individual rights but also about protecting the collective ability of employees to advocate for themselves. Automated employment decision tools represent a new frontier in workplace privacy. These systems use algorithms to screen resumes, score candidates, or monitor performance. Key concerns include bias, transparency, and auditability. If these tools rely on flawed or biased data, they can perpetuate discrimination, raising both privacy and fairness issues. For exam purposes, important terms include audit and transparency, as laws increasingly require disclosure about how such tools operate. Learners should understand that while AEDTs promise efficiency, they also create risks that must be managed through regulatory oversight and organizational accountability. Exam scenarios may test recognition of these emerging obligations, showing how traditional privacy principles adapt to new technological realities. Background screening practices are governed by statutes like the Fair Credit Reporting Act, which impose notice and consent requirements. Employers must inform candidates if consumer reports are used and obtain written permission. If an adverse decision is made, individuals must receive copies of the report and notice of their rights. For learners, this area illustrates how privacy intersects with consumer protection law. Key terms include notice, consent, and permissible purpose. On the exam, questions may describe an employer using a third-party background check and test whether candidates recognize the applicable legal obligations. This reinforces the theme that workplace privacy often depends on laws external to traditional privacy statutes. Polygraph testing is tightly restricted under the Employee Polygraph Protection Act. Most private employers may not require or request polygraph tests as a condition of employment, with limited exceptions in security-sensitive industries. Employers must also provide notice of rights if testing is considered. For candidates, the key takeaway is prohibition, with narrowly defined exceptions. On the exam, learners should expect scenarios that test recognition of these limits. This statute highlights how privacy concerns extend into bodily integrity and personal autonomy, emphasizing that employment rights encompass more than just data. They include protections against intrusive methods of evaluation. Drug and alcohol testing policies also raise privacy considerations. While employers may have legitimate interests in maintaining safe workplaces, testing programs must be designed to respect employee rights and avoid discrimination. Key terms include policy design and confidentiality, as results must be safeguarded and applied consistently. Exam stems may test whether a particular testing program complies with both legal and privacy standards. This area reinforces the balancing act in workplace privacy, where safety and security interests must be weighed against individual dignity and fairness. For learners, understanding these terms ensures recognition of how privacy obligations operate in practical employment settings. Social media monitoring policies illustrate the modern extension of workplace oversight into employees' online lives. Employers may wish to review public profiles or posts, but restrictions arise when monitoring intrudes on protected activities, such as union organizing or lawful off-duty conduct. In unionized workplaces, collective bargaining agreements may impose further limits. For exam purposes, the term's policy boundaries and implications are central, as questions may test whether a monitoring practice exceeds legal or contractual limits. This area demonstrates how technological change continually reshapes workplace privacy, requiring organizations to adapt policies carefully to avoid legal and reputational risks. Employee monitoring technologies span computers, email, telephony, photography, and video surveillance. Each method carries its own expectations of notice, proportionality, and purpose. For example, monitoring email use may be acceptable if disclosed, but hidden surveillance can violate employee rights. Key exam terms include monitoring, scope, and proportionality. Learners must understand that while monitoring is often legal when disclosed and justified, excessive or secretive practices cross into unlawful territory. This reinforces the broader principle that workplace privacy depends heavily on transparency and the alignment of monitoring with legitimate business interests. The Electronic Communications Privacy Act reappears in the workplace context, providing both authority and limits for employer monitoring. Exceptions allow employers to monitor communications if they occur in the ordinary course of business or with employee consent. However, these exceptions are not limitless. For example, monitoring personal email accessed on a work device may exceed legal boundaries. Exam questions may test recognition of when employer monitoring falls within ECPA exceptions and when it becomes unlawful. For learners, this demonstrates how a single statute can shape both government surveillance and private workplace practices, emphasizing the importance of context in applying legal rules. Post-employment privacy obligations also deserve attention. Employers must manage record retention, handle termination processes, and respond to reference requests while safeguarding former employees' information. Key terms include retention, disposal, and confidentiality. For example, retaining records beyond necessary periods may create risk, while careless disclosure in reference checks can lead to liability. On the exam, questions may test recognition of these continuing obligations, showing that workplace privacy extends beyond active employment. This reinforces the concept of the information lifecycle, where privacy duties persist from hiring through post-employment, requiring organizations to maintain vigilance at every stage. By mastering the glossary of domains 3 and IV, candidates strengthen their understanding of lawful access and workplace obligations. Government terms highlight the structured yet controversial ways in which law enforcement and intelligence agencies obtain data, while workplace terms emphasize fairness, transparency, and respect for employees throughout the employment lifecycle. These glossary foundations ensure that learners are prepared not only for exam questions but also for practical challenges in balancing organizational needs with individual rights. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.